In 2016, Jomo Kenyatta University of Agriculture and Technology signed a 6-year commercial lease for a massive building in Nakuru. At the time, the institution was in a period of ambitious expansion, relying on a steady stream of self-sponsored students to fund the new campus. But the agreement contained a significant risk for the tenant. It was an absolute contract, lacking any early exit provisions or break clauses that would allow the university to leave before the 6 years were up. That lack of flexibility became a crisis when two unforeseen events collided. First, a government policy shift drained the university's student revenue. Then, the pandemic forced every campus to shut its doors. By July 2020, the Nakuru campus was no longer financially viable. In an attempt to stop the losses, the university issued a 3-month termination notice and prepared to vacate the premises. The landlord, Kwanza Estates, refused to accept the notice. They deployed private security to block the university from moving its equipment and engaged auctioneers to demand rent for the 14 months remaining on the lease. This standoff created a fundamental legal conflict. When a global crisis makes a business operation impossible, does the law provide a way out? Or does the signed contract remain an absolute financial obligation? The battle began in the Environment and Land Court, where the trial focused on the strict requirements of contract law. The university's defense was centered on the pandemic. They argued that the government-mandated lockdowns had rendered the performance of the lease impossible. To win this argument, they needed to invoke force majeure, a legal provision that excuses a party from their obligations during an act of God or an unforeseen disaster. However, the 2016 lease agreement did not contain a force majeure clause. Without that specific written language, the court had no contractual basis to excuse the university's performance. The High Court ruled that financial hardship is not the same as legal impossibility. The university was ordered to pay over 71 million shillings in rent arrears and building restoration costs. The ruling reinforced a difficult reality. In the absence of a specific exit clause, a tenant remains bound to their promises regardless of external economic shifts. The university took the case to the Court of Appeal, shifting their strategy away from the text of the lease and toward a broader principle of common law. They invoked the doctrine of frustration. This principle allows a court to dissolve a contract if an unforeseen event fundamentally changes the nature of the agreement, making it something entirely different from what the parties originally signed. The appellate court was sympathetic. They ruled that the pandemic lockdowns were a frustrating event that fundamentally altered the lease, effectively discharging the university from its future rent obligations. This decision shifted the balance entirely. It suggested that under the right circumstances, a court could use the doctrine of frustration to release a tenant from a valid multi-year contract due to severe financial distress. The dispute eventually reached the Supreme Court, which was tasked with providing a final resolution on how to balance contract certainty with the practical realities of a crisis. The Supreme Court overturned the appellate court's ruling. It held that financial hardship, even when exacerbated by a pandemic, does not meet the strict legal threshold required for the doctrine of frustration. Because the lease lacked a break clause, the university's unilateral decision to vacate the premises was confirmed as a breach of contract. However, the court applied the duty to mitigate. This rule requires minimizing financial losses after a breach, rather than letting damages accumulate. The landlord couldn't leave the building empty and expect full payment. They had to seek a new tenant. As a result, the court limited the university's liability to just 3 months of rent, a period it deemed reasonable for the landlord to renovate and find a new occupant, along with restoration costs. This judgment enforces a practical limit on commercial lease liability. It confirms that while a tenant is responsible for a breach, the law requires landlords to actively mitigate their losses, preventing a single broken contract from resulting in an automatic multi-year financial penalty.